Hey guys, and welcome to the weekly docket. Hey guys, good morning. And I'm ready for the weekend and hope you are too. But let's don't go there before we check in on some of these crime updates. Some of them are happening today. The Ethan Crumbley sentencing continues today, where the judge will consider whether he gets a life imprisonment or a chance for parole because he was a minor at the time of the murders. And also the Bryan Kohberger hearings are today, but the court's not going to allow that to be streamed. So I don't know whether the judge will make a decision on that or not today. It's quite complicated, all the things he has to consider. It would have been interesting to hear it, but it's not going to happen. Anyway, I'm sure we'll find out from people who do attend. So let's make this bigger. Sorry. All right, let's get rolling here. And good morning to Texas. Potentially one of the few places that's hotter than here and more humid sometimes. So Darrell Brooks, if you've been following along on this, you know what happened on the motion to withdraw, which was a little bit of a curveball in that the judge allowed counsel to withdraw and put in the record that Brooks requested new counsel. And there will be an update hearing in September to find the status of that or report the status of that to the court. I don't know what's going on with it. I don't know if there's going to be another public defender appointed, perhaps, probably. And then will he accept that person and go forward, or will he try and fire that person again later? Or will he simply in September say, you know, I'd rather just do this myself, which is what we thought he was going to say in the first place. So we will find out. An interesting name here, Little Sweden, USA. That's kind of cool. And Los Angeles, 6 a.m. Well, you're up early for this. So, and more alert than I am. So congratulations. All right. Let's move past him. He's done what he's going to do for this month. And I don't think he's worth more than that. 91 degrees in Athens, Greece. Yeah, that's hot. That does count as hot. Our friend Kohberger, I did want to show a little bit of the recent filing, though, before we end up finding out what happens in his case. And this relates to the grand jury challenge. I think we've outlined all the challenges or things that the defense wants about the DNA, especially regarding the family DNA, because the state's given them the rest of it. The defense has some arguments, I think, that aren't very good and some that are good. The state has the same in that case, I think. But to me, that's a sideshow to the main case. Kind of like this, which is the grand jury challenge. And the round one of that was the grand jury was misled. And I saw that reported in the media. But they were misled by being told that the standard for indictment is probable cause. And that actually is the standard in the statute and the standard all over the United States. So they were not misled. The defense said they should be told that they need to find that the crime was committed by Kohberger beyond a reasonable doubt. And that's not the standard anywhere. And it's not really logical because you know as a grand juror that you're not hearing the defense's side of this. So how could you find anything beyond a reasonable doubt? All you're really saying is, from what we see, it looks like this guy maybe probably did it and should have to answer for it. And then you go to the real trial. That's what the real trial is for, not the grand jury. So now we're on to round two, and that is really the form and selection and handling of the grand jury and the allegations of the violations of the Uniform Jury Selection and Service Act, which I suppose was passed in Idaho in its uniform manner, since they're calling it that. But sometimes you get these uniform laws, which are where committees get together and say, this would be a great law for every state to have uniform commercial code and things like that. And then states will pass it. And sometimes they'll pass it exactly like that. And that's great. Hooray. Because when you go from one state to the other and you know what the law is, but sometimes they just change a little bit of it or they change a lot of it or whatever. That's why you see that name in there, I think, in this case. At any rate, a motion to quash the indictment under this requires a substantial failure to comply in selecting the grand jury. So they're not looking to throw out an indictment over some kind of little technical defect. And that makes sense. That would just be a waste of time. So keep that in mind, substantial failure. And to me, that means, you know, if they would have returned the indictment anyway, if this thing hadn't happened, then that doesn't really matter. a tiny error in paperwork, kind of like when people were wondering, is Brooks' whole trial going to be filled out because Judge Darrell let him modify the sacred form? You know, that's not going to happen. But if you fail to legally select the grand jury, and so the grand jury was not lawfully constituted, that to me might be something that would be a substantial failure. So let's see what these arguments are. Sorry, I keep cutting this off so I won't cough on you. I don't want to get anybody else sick. So I didn't put these in order in the brief, but kind of the order that made logical sense to me as I read through them. One of the first grounds of the grand jury challenge is the court-issued questionnaire is a failure of mechanism in drawing the grand jury pool because the questionnaire did not have certain numerical information on all of the forms, only some of the forms. It's not clear what this is, but the state says, look, the information that whatever the clerk or clerical person is putting on there is not shown on the model questionnaire. It's not necessary. It doesn't make any difference or not. It's kind of like the modifying of the sacred form with Brooks. That's what the state says. Well, here's an issue with this is the defense's contentions against this were filed under seal. So Ann Taylor's contentions against the grand jury, we're only seeing what the state is saying about them and not her original contention. So take that in the interest of fairness, that her argument may be more elaborate, obviously, than how the state is recasting it. But I'm just reporting here from what I can get from the record. And the state saying this is outside the scope and not substantial. Now, that sounds right to me, unless she has alleged that that information had some kind of feature to it that would make the selection of jurors not random or something like that. But I don't see it. Then they said, the defense said, court should maintain separate lists of qualified jurors for grand juries and trial juries. It should be separate lists. But the statute says individuals must be randomly drawn from a county jury list and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels or for a grand jury. To me, that says you have a list and you draw the jurors for these panels or a grand jury off the same list. So the state says this is not even the right reading of the statute. The statute has no requirement for dual list, and I think that's right too. This is like a CLE, but more interesting and timely. It's less expensive than a CLE too, since you don't have to pay to be here. And this one gets a little more interesting to me. Again, we can't see what Taylor is saying directly, but only the state's response. And they announced form failures. One juror marked that they do not comprehend English, but apparently they filled out the rest of the form and participated in the grand jury proceedings. So they mismarked a box. Do you throw out an indictment for that? I doubt it. One juror disclosed that he was a prior criminal defendant. That doesn't disqualify you from being a juror, so I don't think that's an issue. And one juror did not mark whether the person was a defendant and did not sign or affirm the form. That could be more substantial. You know, the statute has in there that you can find that out through the questionnaire or interview or other competent evidence or whatever. But if there were going to be one that would matter to me, that one might be the most. Now, the state says, look, all you can challenge is the process, and you haven't done that accurately. So this gets down into the weeds over technical things. And the final ground, which was the most interesting, but of which we see the least, is the allegation of juror bias or statements made by the court during selection of the jury. So the state says this is outside the act. The act contains a provision in it, which it should, that says that the selection of jurors, the jury pool, it cannot discriminate against people for the type of things that you might normally think of, gender, or race, and things like that. So I don't know what they're talking about here, about juror bias. The state just says, look, this kind of complaint is outside the act, so I can't assess whether there's anything to this or not. Did the juror say, well, I hate anybody named Kohberger, I don't care? I don't know what Ann Taylor said, so I'd just be making something up to tell you whether I think there's something to this or not. So unfortunately, her stuff is filed under seal, so we just don't know. But you know, Idaho doesn't have as much law as some states like California, and often they're quoting cases out of California because people try to bring those in since they have a smaller appellate pool of decisions to draw from. That's the way it is in states that are more rural. But nevertheless, I think this is what I'm about to say is correct, and I won't have to report myself to the Department of Corrections. that if the defense were to win all this, the statute actually does say there, the court shall stay the proceedings pending the selection of the jury in conformity with this chapter, quash an indictment, or grant other appropriate relief. So they could quash the indictment, but the general rule is if the indictment is thrown out, then you're just going to get indicted again if the state wants to do it. That's not double jeopardy by itself. So this is a lot of litigation early in the case, and that's fine, but I don't know what it really would do even if the defense were to win here. So sometimes these things aren't really litigated that much because it's, there's probable cause. You're going to go to trial, and your focus really is on the motions in limine and the things that have to do with the evidence that will be in actual trial. But that's not to disparage the defense for making this an issue, because that's their right to do it. What I am saying is it's not like if they get a technicality in the grand jury pool that this case is over, and if this guy did it, he can just prance around and start murdering people again. The state could bring him back to court with a new indictment. Lori Vallow. Well, I hope she has her traveling bags ready and her prison makeup kit ready to travel, because she is going to head to Arizona, it looks like. And remember, she's facing 2 conspiracy counts to commit murder, so she's not facing the death penalty there. And what I've got quoted over here on the left is a little thing that I know is not so important these days, but it's a thing called the Constitution of the United States of America. And it says, a person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. You can tell from that there are a lot of lawyers involved in writing the Constitution, but it's basically saying that if somebody is charged with a felony in one state, the governor of that state wants that person brought there and they can find them in another state, then the other state is supposed to cooperate with that. And of course, you see that all the time. I mean, that's how they get her to Idaho. That's how they get Kohberger from Pennsylvania to Idaho. So that's how it works. And I've seen it. There's somebody popular who was involved in high-level government who was indicted recently in Georgia, and I saw some legal advice being given that he should just ignore the indictments. And whatever you may think of the indictments, ignoring them is not the answer, because the idea that Georgia has no jurisdiction over anybody outside their state lines, it doesn't fly with the Constitution, so it has to be addressed. But in that case, which we will not talk about here, there will be some very interesting legal arguments, but it's hard to get into those without people completely losing their minds. Lori's face does look like it's melting, is the comment here. It certainly does, and I guess it's wearing on her being where she is. And it should, because what she did was absolutely evil. She still seems to be enthralled in that from her closing statement, but just terrible. This was the statute I showed before, that you don't get a death penalty for conspiracy, but you can get life. Austin Ford, bringing us up again, really to touch on double jeopardy a little bit more, since we've covered that some, and you can see it flying and being an issue in several of these cases. This guy had this story going on. He was accused of murdering his friend, Toria Lang. They were both pretty young at the time, just coming out of being teenagers, or maybe right at the tail end of that. She was found shot to death under a tree in a park. Now, he originally denied going to the park with her. He said she showed up and said, "I want you to kill me," which he reasonably declined to do, he says. And then she leaves. Well, he didn't know what happened, but she ends up killing herself, he thinks, or he's told. He didn't have anything to do with it. Unfortunately, evidence came out later that showed that he was connected to that location. I think it was his phone and other stuff. So he said, well, you know what? Actually, I did go with her to the park, but only to try and talk her down out of this. Okay. And at the park, he says he managed to get the gun from her, put it on the ground, and then tried to hug her. And that's a very nice thing to do. When she reaches down on the ground, grabs the gun, and shoots herself. He panics at that point and grabs the gun and takes off in her car, which was a thing apparently she said she wanted him to do after he kills her, which is what he said she wanted him to do, but he says he didn't do. But then it did occur to him to go ahead and take the car. He left it somewhere. It was found torched later, and he goes, but I didn't torch it. Well, he went to trial twice, and the jury's deadlocked. So the state said, well, you know what, we're not going to do it again. We're not going to have a third trial. And this goes into this double jeopardy thing of, yes, you can have a retrial after a mistrial declared because of a hung jury. And the state, if they wanted to, could have come back for a third trial. he is getting 10 years on other charges. And maybe he's very lucky, because if you saw this other case that just resolved in Texas versus Armstrong, this young fellow was convicted on his third trial after 2 hung juries for shooting his parents with a .22 caliber handgun through a pillow while they were in bed. He says he didn't do it. I don't know if he did or he didn't, but the third jury said that he did. And then the FedEx trial, shooter trial, if you saw that happen yesterday, a mistrial was granted in that due to discovery violations by the prosecution. Now that gets a little closer to double jeopardy, because you're not dealing with a hung jury and the manifest necessity of justice to allow the trial to be redone. You're dealing with a state infraction. They didn't turn over a discovery. So if there's misbehavior by the state and the mistrial is declared because of that, how come it's not double jeopardy? In that case, the defense moved for the mistrial. And as from what I quick look at the law down there, I think it was Mississippi or Missouri. Either way, I looked it up, and they said that the state has to be goading the defense into making the motion for mistrial. So if the state does something intentionally to try and throw the case so that it can have another shot at it or something like that, then in fact it would be barred by double jeopardy, and they wouldn't be able to bring it again. But it didn't. The judge wasn't making that ruling. He said, we'll just tee this thing up and try it again. And I did see a lot of complaints in that case that it's a good old boy network, and it was all a plan to help these guys, because I guess just glancing at it, the DA is white, the judge is white, the defendants are white, but I think the victim in the case was black. So I hear that. I'm not sure how this will help them to go to trial again, though. I mean, if you were going to good old boy it, you just would hide the evidence. And if you were the DA, you'd get through the trial doing a terrible job so that these guys wouldn't be convicted, right? Instead of turning over the evidence when you find out about it during the trial, and then there's a mistrial and these guys will get to go at it again. Something like that. I don't know the particulars of the case, but I can understand the sensitivity to it, but it seems an ineffective strategy to good old boy it to get to have another trial. If you were trying to throw the trial, just throw the trial. But that's all I know about that case. All right, now I'm going to bring up something that somebody asked me about in the chat before we got started, and that is the Leticia Stauch case. So let me pop this puppy up. And the question was, does she have to pay restitution? Now, I had a vague recollection of that, so I was checked quickly before we came on the stream, and the father of Gannon said, I don't want restitution from her because I don't want to be connected to her after she goes to prison. I want to leave her behind. I don't like the thought that she's used my last name. I don't want a connection to her. There's nothing she has, any money she has, that's worth being connected to her in the future. But it looks like the judge respected that. You can see here that in her judgment of conviction and sentence, she's assessed $754. I don't know what that's for, but that's obviously not some serious ongoing restitution. That's probably some kind of cost inherent to the system. So we did get to answer that question. So what else have we got that's going on? So I'm still trying to get well, and hopefully we'll be that way by the weekend. It's pretty bleary-minded yesterday, I have to say, and hard to read the screen, but I'm reading it better today. I think I'm getting most of the words right. Oh, yes. Good point. Thank you for bringing that up. And the Austin Ford case had another spin on it in that, I think it was the Austin Ford case, his mother was taking pictures of the jury. And that's a no-go. That's a no-go. And the judge seized her phone and made her go to jail for a few days. And I think was giving her the phone back after that. I'm surprised he didn't put it in airplane mode and destroy it or something like that. I mean, you shouldn't be doing something like that. But she had to go, yes, back up here. It was the Austin Ford case. Yeah. So the judge handled that. And he seemed kind of a no nonsense on that. Thanks for that. I am getting better. You know, there's a lot of things running around these days for people to catch. So that's it. This one's pretty quick today because some of the major hearings are actually going to go on later today. So I won't drag it out any further. So what I'd like to do next week is come back to this indigent thing that somebody had asked about earlier. And maybe we'll use the Sarah Boone case as an example of that. I found her request, her affidavit of indigency form, and we can go over that in Florida and maybe North Carolina and another state to show how it works and It's not so confusing, but it's a little interesting maybe how that is and some other things. Any thoughts on the Depp v. Heard Netflix show? No, other than I've been watching people commenting on it and how much of other people's content Netflix used to make it, and then apparently striking those people for their own content after that, which seems to me incredibly poor form. Phones, etc., will be banned if it keeps going on. I mean, I'm way old school. I'd love to have all of that stuff banned. I'd love to have it all banned out of the courtroom, and you can put it in a cubicle or something like that and get it when you come out, as well as Broadway plays, movie theaters, and things like that, because people choose to not behave. People don't silence things. They don't turn them off. They use them when they're not supposed to. But I recognize that makes me very old school. Very old school. So I think the AA Legal Focus channel has an interesting stream coming up that you guys should check out. And I mentioned that yesterday, that there's some excellent content there, especially on the Adelson case, which is fascinating on the facts, tragic in what happened, but just an incredible series of events that involves lawyers behaving badly. All right, guys. Well, I hope everybody has a good weekend. And when I get my mind clear, I'll have some other, hopefully, some solid content to come up with. And we'll have some member content out as well soon, as we normally do, because next week's the week for that. All right, everybody. Thanks, and have a great weekend.